Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today I'm filming from my house in Florida, so it looks a little different than it does from my usual studio. So today I want to talk about a case called Cockerham versus American Family Insurance. More on that in just a moment. Before we get started too far here, I want to make sure everybody understands this is talking about one case. This is not how American Family acts in every case. Most of the issues that were caused in this case were caused by the lawyers, not the insurance company. I'm not going to name the lawyers. I'm not going to embarrass anybody else, right? I'm simply saying that just because American Family took these positions here doesn't mean they're going to take them in your case. And you need to be aware of that. American Family, generally speaking, is a very good company, very stable company. It's a very profitable company. It's a mutual company. So it looks out for you. Every now and again, these kinds of claims and issues erupt. And when they do, you should seek a lawyer. Now let's get on with a discussion of the case. Generally speaking, I don't like to talk about cases until they're resolved. For one thing, you can wind up terribly embarrassing yourself by talking about something before it's final. And I try hard not to embarrass myself, although I do it on a weekly basis at least once. So today we're going to talk about this rather interesting case out of Missouri. Now, I never set out to become an expert on insurance, and I don't claim to be an expert on insurance or insurance law. But I have developed a line of cases in my practice where I have dealt with insurance law, and it's usually been fairly successful. But this case is unique in several ways, and we'll get to that in just a moment. Bob Cockerham always wanted to have a really nice telescope. Now, Bob is himself a lawyer, a very good lawyer, and also, coincidentally, a lawyer who deals with insurance. And Bob wanted this telescope, and in order to have a really good telescope, in other words, not one mounted on a tripod, you have to do certain things. You have to put in certain supports for the telescope so that the telescope does not move. It has to be basically welded to the bedrock. Anything that would make the telescope move, even a little, like rumbling of a train on tracks nearby, or anything that would make the telescope move, even a little bit, could cause the difference between seeing something that you're looking at and seeing something 1,000 miles away from what you're looking at. So Bob went and hired an architect, and he had the architect design plans to put his telescope into his house and create a little observatory. Now, before he did this, he went to his insurance agent and said, I'm getting ready to start on a project where I'm going to be remodeling my house. And I want to make sure that I'm covered. You know, if a spark from a welding torch or if something, that I'm not anticipating causes a fire or I get a flood as a result of this, I need to know that my homeowner's insurance is going to take care of me, because if it isn't, I need to know that. And his insurance agent said, oh no, you have our Gold Star policy. It's our very best policy. You have nothing to worry about. Everything will be covered. So this is the first teaching point in your video here, and that is this. The first teaching point is just this. Never take the insurance agent's word for what is covered and what is not. Unfortunately, you are not going to know what is covered and what is not covered until the adjuster comes out and makes a determination as to the cause and origin of any fire, as well as the cause of any other damage. And the sides of the insurance business are twofold. One side, called the underwriting side, is interested in selling policies. And the other side of the business, called the claim side, is very interested in not paying claims. Your insurance company will be your best friend when they are trying to collect their premiums. And they will be your worst enemy when you have a claim. Now, that's not all insurance companies. And in this case, we're dealing with American Family. And to be fair, that's not always true of American Family. But a lot of times, unfortunately, that is exactly how the insurance business works. That's based on my experience over the course of the last 25 years. So what happened with Mr. Cockerham's build? Well, the first thing that happened was he hired a contractor by the name of Schalk, and Schalk was not a very good contractor. And even though the architect had provided plans and drawings and everything else to give him the basis to put these piers in the ground and do the things that needed to be done, Schalk made some errors. First of all, Schalk did not install the piers. They were installed by a helical piering company. And the helical piering company basically sunk these piers down into bedrock. And when they sunk those piers down into bedrock, the next thing that needed to happen is there needed to be a concrete cover poured over the helical piers so that there wouldn't be moisture and other things that got down in there and caused the piers to degrade over time. In the process, Mr. Schalk made some errors. He negligently poured the concrete and he ruined the helical piers. In addition, as he was doing this construction, he made a number of other errors in the process, and there were, at the end of the deal, the piering and the support for the telescope went straight through the middle of the family room. If you can imagine having a giant pole right through the middle of your living room, that was pretty much what Schalk had done in order to stabilize the telescope, and even that didn't work. So Bob did what anybody would do in that situation. He went to his insurance company and said, make this right. Now, he tried to do that, but unfortunately, the promise of the insurance agent that you've got our best policy and it's going to take care of you did not actually pan out to be true. So Mr. Schalk was basically looking at bankruptcy. He had had a number of other reversals of fortune, and although he was insured, the insurance company had paid out other claims. There wasn't a lot of money, and Mr. Cockerham settled with Mr. Schalk for what he could get, which wasn't a lot of money, and it wasn't even anywhere near what the damages were. So as a result, he went to his insurance company and said, you need to make me whole. And they said, no, because there is an exclusion in the policy that covers this. So here is the policy language of that exclusion. And I think you'll find this interesting. You have to follow along closely, and I'll put it up so that you can see it. The following exclusions apply to coverage A, dwelling and dwelling extension. We do not insure for loss caused by any of the following. And then one of them was planning, construction, or maintenance, meaning faulty, inadequate, or defective construction, reconstruction, repair, remodeling, or renovation. That's the exclusion. Well, that seems to settle the issue, doesn't it? You're not going to pay for the damage caused by Mr. Schalk. Oh, but wait. There was an exception to the exclusion written into the policy. And here is what the exception said. However, we do cover any resulting loss to property described in coverage A, dwelling and dwelling extension, not excluded or accepted in this policy. So, Mr. Cockerham went to American Family and he said, look, you don't have to pay for the faulty construction. I can pay somebody to get the concrete removed and to re-pour concrete when it's time. But I need somebody to go in and repair the site. There's now damage to the foundation. I need the helical piers removed and reinstalled. There's a large block of stuff that needs to be done to make this right, and I need you to do it. So you don't have to pay for the faulty construction, but you do have to pay for the resulting losses because they're not accepted by your policy. What he did was he gave them a list of things that they had to pay for and what they didn't have to pay for. For example, look at this table. It says the concrete must be removed and replaced because of the faulty workmanship. It is not covered. The helical piers. The piers must be removed and replaced. The resulting losses exception applies, and it's a covered harm. The same thing with the flooring and the foundation. But the water leaks in the roof, those have to be repaired, and that's a result of faulty workmanship, and that's covered by the exclusion, so it's not covered by the policy. And then finally, interior water damage to the home, which resulted from the water leaks in the roof, those are resulting losses that are covered by the exception. Well, as you might imagine, American Family took a different view of that, as they are entitled to do. It's their policy, they wrote it, they can often offer an explanation of what it means, but it has to be consistent with the plain language of the policy. And what they said was, although the resulting loss exception covers resulting losses, it doesn't cover losses resulting from faulty construction. And they denied the coverage. So, under Missouri law, there is a claim called vexatious refusal to pay. It is a special statutory action that gives an insured, like Mr. Cockerham, a remedy against the insurance company. So Mr. Cockerham brought a breach of contract action against the insurance company for not paying the claim, and he brought a vexatious refusal claim against the insurance company for vexatiously refusing, in other words, unreasonably refusing to pay his claim. So, the first thing that happened was the claim against the insurance company went to court, and both Mr. Cockerham and American Family filed what are called motions for summary judgment. Now, a motion for summary judgment in Missouri is governed by Rule 7404, and it is a procedural rule. The thing with motions for summary judgment is that, according to our courts, they border on a denial of due process because they take issues away from the jury. But in the legal sense, if the issue is one of legal interpretation of a contract, that is what the judge does. If there's a disputed issue of fact, that's what the jury does. So what Mr. Cockerham said is, we can decide this on the facts of the policy. And American Family said the same thing. Absolutely, we can decide this on the basis of the plain language of the policy. So when Mr. Cockerham filed his breach of contract action and vexatious refusal claim, he filed those and he sought summary judgment on both of those claims. American Family sought summary judgment on the underlying breach of contract claim only, because if it defeated the breach of contract claim, the vexatious refusal claim would go away. There's no vexatious refusal, obviously, for a contract that was not breached. So essentially, American Family took the position at the trial court, as I said, that essentially the contract excluded this particular kind of harm. Well, under the best laid plans school of thought, when I recorded this, I recorded a lot more than 15 minutes at one time. I didn't think I did, but when I get started telling the story, it gets to be a little bit longer than it should be. I'll pick this right back up in the next video, which should be released tomorrow. So we're going to do several videos on this case, and hopefully they will be illustrative and give you some good information on this particular case and how you might apply it in your life, at least with respect to how you get along with your insurance company. So thanks for watching, and I'll catch you on the next video.